All right, welcome. Today we're going to dig into a really fascinating case, Bradley v. American Smelting. This is where we get to see a court wrestle with a classic problem. How do you take these ancient property rules, like trespass, and apply them to a totally modern issue like industrial pollution? It's a great one.
So, let's get right to the heart of it. The big question this case tackles is, can something you can't even see trespass on your land? I mean, we're talking about microscopic particles from a factory. Do they count as a physical invasion? That's the core conflict here. So we're going to break this all down using our trusty FIRAC method. We'll hit the facts, the legal issue, the governing rule, the court's analysis, and then wrap up with the conclusion and the big takeaway. Let's dive right in.
All right, first up, let's lay out the facts. We need to set the scene. Okay, so here's the setup. You've got the plaintiffs, the Bradleys, who own property out on Vashon Island. Then you have the defendant, Asarco. They run this big copper smelter about 4 miles away. Now this smelter is pumping out microscopic particles, and not just dust, we're talking arsenic and cadmium. And here's the kicker. Both sides agree these particles are landing on the Bradleys' property. And Asarco isn't in the dark here. They've known since way back in 1905 that the wind carries this stuff right over to the plaintiff's land.
Okay, so with those facts on the table, what's the actual legal question? Well, the lower court was a bit stuck, so it punted the case up to the Washington Supreme Court with 3 very specific questions it needed answered.
And these 3 questions really form the pillars of the whole case. First, was there legal intent for a trespass? Second, can this whole situation be both a trespass and a nuisance at the same time? And third, and this is a big one, do the Bradleys actually have to prove they were harmed to have a case?
All right, so to answer those questions, what's the law the court is going to use? Well, it all boils down to the legal definition of one single word: intent.
Now this is absolutely crucial. When we talk about intent in tort law, it's not what you might think. It doesn't mean you had this evil plan to cause harm. Nope. It just means you either wanted the result or, and this is the key part, you believed that the result was substantially certain to happen because of what you did. That substantially certain part is everything.
And the court uses this absolutely brilliant analogy from Prosser on Torts to drive the point home. It says, "The man who fires a bullet into a dense crowd may fervently pray that he will hit no one, but since he must believe and know that he cannot avoid doing so, he intends it." Wow, that just nails it, right? You don't have to want to hit someone. The fact that you know it's pretty much guaranteed to happen, well, that's legal intent. Okay, so this brings us to the real heart of the case, the A in FIRAC, the analysis. Let's walk through exactly how the court took that rule and applied it to the facts here.
So the first big puzzle for the court is intent. I mean, think about it. Asarco wasn't, aiming its smokestacks at the Bradleys' land. So how in the world could they have intended to trespass?
Well, the court connects the dots with some pretty straightforward logic. Step 1, Asarco made the choice to operate its smelter. That was a voluntary act. Step 2, they knew full well that operating the smelter meant these particles were being released. And step 3, Physics 101, right? What goes up must come down. They knew those particles would be carried by the wind and eventually land somewhere. So putting it all together, the court concludes that the particles landing on nearby property wasn't just possible, it was substantially certain to happen. And boom, that's how you get to legal intent.
Okay, next up, the court tackles that second question. What's the difference between trespass and nuisance? Think of it this way. Trespass is all about protecting your right to keep people or things off your property. It's about a physical invasion of your space, your right to exclusive possession. Nuisance, on the other hand, is about protecting your ability to use and enjoy your property. This is stuff like terrible smells, constant noise, or vibrations from a nearby factory. So the big question is, can one act be both? The court's answer is a clear yes. It says, look, these particles are a physical invasion, so that's a trespass. But they also interfere with the Bradleys' ability to use and enjoy their land, so that's a nuisance. The claims aren't mutually exclusive. They can absolutely sue for both.
And that brings us to the final and maybe most important question, the one about damages. See, under the old common law, any physical trespass, even just stepping 1 foot on someone's land for a second, was technically actionable. You didn't need to prove you were hurt. But does that rule really make sense in our world? We're talking about invisible particles that are pretty much everywhere in an industrial society. And this is where the court makes a really bold move. It basically says, you know what? No, that old rule just doesn't work here.
It recognizes that for this new type of trespass by microscopic particles, the law has to evolve. I mean, can you imagine if anyone could sue a factory for a single harmless particle landing on their property? The courts would be flooded, and it would just become a way to harass businesses. It's totally impractical.
All right, let's put it all together. Here's the court's final holding, which gives us the clear answers to those 3 questions we started with. So here's the final ruling. First, did ASARCO have the intent for trespass? Yes. The court says their knowledge meets the substantial certainty test. Second, can the Bradleys sue for both trespass and nuisance? Yes again, the claims can coexist. But third, and this is the real game changer here, can they win just because the particles landed there? No. For a trespass claim involving microscopic particles, the plaintiff must prove that they suffered actual and substantial damages.
And that right there is the key takeaway from this whole case. The court takes a rule that's been around for centuries and updates it for the modern world. It creates a new balance. Yes, property owners have rights, but we also have to deal with the realities of industrial society. So for this specific type of trespass, you have to show you were actually harmed.
So what happens next? Well, this decision doesn't actually end the case. It just sets the rules for the next battle. The case gets sent back down to the lower court, and now the ball is in the Bradleys' court. They won the legal argument, which is huge, but now they have the tough job of proving that these invisible particles caused them harm that was both actual and substantial. The fight's not over yet.